Right out of the gate, this courtroom is about to turn into a legal masterclass in what not to do. We've got a defendant, or someone claiming not to be the defendant, trying to pull a classic sovereign citizen move, throwing around terms like attorney in fact and questioning the court's authority. But here's the twist. This judge is not playing along. What starts as a routine docket call quickly spirals into a full-blown shutdown of legal nonsense. The tension? Immediate. The confusion? Intentional. And the outcome? Let's just say, this strategy is about to get absolutely dismantled. Stick around, because what happens next is a brutal reality check on how the law actually works.
All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me. Apparently there's a copy here.
And there it is, the moment everything starts to unravel. Attorney in fact might sound official, but in a criminal courtroom it's essentially meaningless unless backed by proper legal authority, and even then, it doesn't replace a licensed attorney. The judge immediately zeroes in on this because representation in criminal cases is strictly regulated. You can't just declare authority and expect the court to accept it. This is a classic tactic often seen in sovereign citizen arguments using complex-sounding language to challenge jurisdiction. But here's the real question. Do you think this is confusion or a deliberate attempt to dodge accountability?
All right. This is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the, that's the respondent and heir signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation.
This is where the judge draws a hard legal line, and it's an important one. In criminal law, representation isn't flexible. You either represent yourself or you're represented by a licensed attorney. There's no middle ground, no creative, loopholes, and definitely no attorney-in-fact workaround. What the judge is doing here is protecting the integrity of the legal process. Because imagine the chaos if anyone could walk into court and claim authority over someone else's criminal case. It's not just invalid, it's illegal. So now the question becomes, will this individual back down or double down?
And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Question. Is that an Article 3 trial?
To what?
Will that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. And I'm talking you.
And just like that, the entire argument collapses. No documentation, no authority, no standing. What we're witnessing is a textbook example of how these pseudo-legal strategies fall apart under even basic scrutiny. The judge isn't even being harsh here, just precise. Courts operate on evidence, documentation, and established law, not interpretations pulled from misunderstood legal concepts. This is the moment where the illusion breaks. But instead of stepping back, things are about to escalate even further. So ask yourself, why continue pushing a strategy that's already been shut down?
Stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a possibility of the jury warrants? I'm going to put a notice up there for tonight. If we don't need you tomorrow, but we need you on February the 7th would be a day I could give it. Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry,
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me who's...
Now, this is where the judge completely takes control of the courtroom. And honestly, it's necessary. Filing documents in the wrong court, citing irrelevant civil cases, and throwing around Latin phrases doesn't strengthen your argument. It weakens it. The judge identifies every flaw one by one and shuts them down in real time. This isn't just about one case anymore. It's about maintaining order and preventing the misuse of the legal system. And when the judge says you need to listen, that's not a suggestion. It's a warning. So let me ask you, at this point, would you stop or keep going and risk making things worse?
His name must not be uttered. Then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are, in fact, Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
And there it is, the final ruling, clear and decisive. The judge invalidates the entire argument because it fails to cite any relevant criminal statute. That's the key takeaway here. In criminal court, only criminal law matters. Civil arguments, misapplied cases, and pseudo-legal theories simply don't hold weight. The defendant is now facing a rescheduled trial with a clear warning: show up properly or face serious consequences, including jail. This case is a powerful reminder that the courtroom isn't a place for experimentation. It's a place for law, structure, and accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.